What up, YouTube? It's your 2A Rights Defender back with another one. Today, we're going to be discussing a real important case that's coming up in the Supreme Court that's to be heard soon, and a lot of other advocates have talked about it. I want to go over it because it's in direct correlation with me. So today, we're going to be talking about Garland v. Range, okay? So I'm going to read basically what pops up on the internet when you look up this case. So it says, Garland v. Range is a significant Second Amendment case that has been making its way through the courts. The case challenges the constitutionality of a federal law that prohibits people who have been convicted of non-violent offenses from owning guns. Background. The case involves Brian Range, a man who pleaded guilty to a nonviolent crime in 1995 and was subsequently prohibited from owning firearms under federal law. Range argued that the law violates his Second Amendment right to bear arms, and the U.S. Court of Appeals for the Third Circuit agreed, ruling that the law is unconstitutional as applied to him. Okay, so it says the Supreme Court has not yet issued a decision in Garland v. Range, but it is granted certiorari, which means agreed to hear the case, and oral arguments were held in November 2023. The court's decision is expected to have significant implications for the Second Amendment and gun control laws in the United States. Okay, now it says the key issues are the scope of the Second Amendment. The case raises questions about the scope of the Second Amendment and whether it protects the right to bear arms for all individuals, regardless of their criminal history. Okay, the constitutionality of felon in possession law. The case challenges the constitutionality of the federal law that prohibits people who have been convicted of non-violent offenses from owning guns. And number 3, the history and tradition test. The case involves the application of the history and tradition test, which is a framework used by the Supreme Court to evaluate Second Amendment challenges. The test requires that any firearm regulation be consistent with this nation's historical tradition of firearm regulations. Okay, so the implications are the outcome of Garland v. Range has significant implications for gun control laws in the U.S. If the Supreme Court rules in favor, which I really hope it does because I'm going to explain why, it could potentially strike down the federal law prohibiting people who have been convicted of non-violent offenses from owning guns. This could lead to a broader expansion of the Second Amendment rights and potentially undermine gun control efforts. On the other hand, if the Supreme Court upholds the law, it could reinforce existing restrictions on gun ownership and provide a framework for evaluating the constitutionality of future gun control laws. Okay, so in conclusion, Garland v. Range is a significant Second Amendment case that has the potential to shape the future of gun control laws in the U.S. The case raises important questions about the scope of the Second Amendment and the constitutionality of gun control laws, and its outcome will have a significant implication for individuals, communities, and the country as a whole. Okay, and that's a good explanation. Now, the reason why I'm making this video is because in a case like this, non-violent misdemeanors, I don't know, the federal government calls me a felon, but if my state offense is not a felony, it should not be classified as a federal felony, for one. For two, all the gun control laws fail the history and tradition test besides disarming violent offenders and violent repeat offenders. Okay, so my Maryland 4203 is a direct violation of my Second Amendment right. If I'm a law-abiding, virtuous citizen, okay, and I'm caught or I'm stopped by an officer with my legally possessed firearm, concealed or not, that is my Second Amendment right to carry. It should not be any handgun qualification licenses or anything that I have to get to exercise that amendment. Okay, so possession of a firearm should not be a criminal charge if you're under the law, which means I was bound by the Second Amendment. My firearm in 2011 was clean. It was not registered, but it was a clean gun. Okay, it was my personal firearm. Okay, so this is where we're getting to, because a lot of the gun control laws do not follow the history and text. In those days when this Constitution was written, possession of a firearm was not a criminal offense. I had a squeaky clean background, and this is the only violation on my background. So basically, it's showing that Maryland turned me into a criminal. You see what I'm saying? You labeled me a criminal. I'm a non-violent misdemeanor. Okay, so this is why this case is very important, because it's going to free up a lot of this junk that these states are doing that's actually tying up the Supreme Court. The Supreme Court should not have to be solving stuff like this. You see what I'm saying? But because these states are over supplementing with their own little statutes, they're locking you up for a Second Amendment right. When I was arrested, like I said, I was a passenger in someone's car. Technically should have just been even a traffic stop. I was in what they call unlawful possession of a firearm. It's not unlawful if I'm just simply following the Second Amendment to begin with, by just having it on me. That is just possession of a firearm. That's not illegal according to the Second Amendment right. So this is why this stuff needs to be, it definitely needs to be changed. The felon in possession law has to be altered. It has to say violent and repeat felons. Like repeat, and I say repeat violent. The only way they say repeat felons is because if you get one felony and you keep repeating, you know you're doing bad stuff. You see what I'm saying? But nobody's perfect. It's a misdemeanor to walk across the street, not in the crosswalk. You see what I'm saying? But if a state decides to make that 5-year maximum sentence and the officer catch you jaywalking and lock you up being petty, you get disarmed because you got caught jaywalking. See, the way they're playing with the Second Amendment is they're blaming gun crimes, okay? But people don't only use guns to harm others. Like I said in one of my previous videos, I'm a victim of a home invasion. So being disarmed doesn't really help. Secondly, the guy used a crowbar or something to break in my house. So you're going to go out there and make laws that ban crowbars? You see what I'm saying? It's the same thing y'all are doing. This case is very significant. Now, the part that damages is the implications, the outcome. Because it says, on the other hand, if the Supreme Court upholds the law, it could reinforce the existing restrictions on gun ownership and provide a framework for evaluating the constitutionality of future gun control laws. Yes, it will provide a framework, but that's basically saying it's going to allow them to keep making more and more and more and more crappy bans. Okay? So, like, you got assault weapon bans and magazine bans. First off, a lot of the stuff that y'all are talking about is not assault weapons. A modern sporting rifle that we have as civilians are not military grade weapons. They will not use these little AR-15s that we have in this country to fight. Because first off, their military ammo will blow up these guns that we have. You see what I'm saying? Because they have way more powerful ammo. Secondly, an assault rifle, that's a made up term for military rifles that are made for the frontline soldiers that are advancing and they have fully automatic capability. Okay? But what you have to understand is every type of firearm fell under the Second Amendment when it was written. So if you're following the history and text, the history and tradition text, automatic weapons should be allowed. Because that includes advancements on technology in those days. Okay? So if we had muskets, you see what I'm saying? And the first person that came up with the center fire revolver cartridge, that's an advancement in technology. That falls under the Second Amendment because that's the first thing you're going to do is grab the more advanced version. See, this is what we have to understand, that a lot of the gun laws that are being placed upon us do not fall under the history and tradition text. Every firearm is under the Second Amendment, okay? You keep talking about, like Maryland said, something about it's called an assault weapon because the military can use it. And you're being hypocritical. You contradicting yourself. Because like I just told you, the military does not use modern sporting rifles. Their barrels are thicker. They're made with different material, way better. Bigger and more hot ammo, okay? So it's a difference. Like I said, if I put a 5.56 from the military inside of a modern sporting rifle 5.56, it's going to explode because it has too much back pressure. It's not even the same caliber, like the same type of ammo that they shoot as civilians. You see what I'm saying? So you have to understand that all these gun rights are being violated because when they're writing new law and policy, they do not fall under the history and tradition test. They're trying to adapt it to modern times. We understand that in a sense, but everything follows under the Second Amendment. Y'all keep trying to ban the most commonly used weapons among civilians. Fully automatics, it falls under. It should be no bureaus telling us how to exercise the Second Amendment right that was written to protect a God-given right. So I don't like the felon in possession law as far as how it's currently written. It needs to be revised, like I said in the last video. Okay, then it says it's going to range on the scope of the Second Amendment. It ain't no scope. It clearly says shall not be infringed. Shall not be infringed. 4-word slogan. It's not hard to understand. That means you can't put regulations on my guns. You can't tell me I can't carry. Now, we understand common morality. Who wants to walk around in civilian population with RPGs and explosives and grenade launchers and stuff? You got to be a dumbass to really want to do that. That's military grade weaponry. So this is all I'm trying to get to. It's a lot of little simple stuff. Y'all don't follow the basics that it's telling you. History and tradition test. Non-violent felons is no such thing. Because most of what y'all call non-violent felons were misdemeanors. They weren't disarmed. You barely did. You did a night in jail and made bail. You got out in the morning or probably got out off personal recognizance. You have to understand. They're making all these little stupid offenses felonies simply to make it fall under 922G1. You have to make it say violent offenders, people who are out to harm others or have bad mental health or have bad violent histories. I did not have one strike on my record. Maryland locked me up with a firearm simply possessing it. So by you doing that, you violate my Second Amendment right. So it's basically the state saying you have no Second Amendment right. So this is why this case is the most important case that's about to be heard in June. It's the end of May. So basically in a few weeks, it's really important. We need the Supreme Court to vote on behalf of this because this is going to free up a lot of junk cases that y'all have to keep sending back down, which they're not going to change their mind and keep coming right back up to y'all. It's so many people that these states are just trying to disarm through these little petty crimes. That has to be revised. So if things have to fall under history and tradition text, then simple possession of a firearm was not even a criminal offense. That means that I shouldn't even have a criminal record. Especially if I'm in a traffic stop, I'm not the driver. The officer knows I have my firearm, but when he runs my record, I have no offenses. That means that I can clearly exercise my Second Amendment with enough mental capacity and enough mental fortitude. So this is all I'm trying to get to, man. This is your 2A rights defender, man. We about to keep fighting because this is the case that is important. Everybody needs to understand this. We got to stop worrying about for right now, all the magazine bans and stuff. We need our firearms, period. But Maryland, I have it out for them as far as gun control because they are the leaders of it. They keep coming up with all this crazy stuff and they writing it under their own guise. They're not writing it under the history and tradition. They're writing laws based on their own feelings. That's not what you do. You don't label a modern sporting rifle an assault weapon and say it's not allowed in this state because the military can use it. The civilians are the militia. We are the sub-military. And like I said, military weapons are way more higher grade, okay? So this is what I'm getting to, man. That's the end of it. I'm not going to keep dragging too long, keep repeating myself. 2A rights defender, watch out for Garland v. Range, man. Hopefully the Supreme Court rules in our favor. Because then I can get my record expunged. Maryland will have to expunge it because then it's like I'm a non-violent misdemeanor, but mine is not eligible for expungement because you want to disarm citizens. And I was an out-of-state resident when I caught that case. The Supreme Court also needs to do that. The federal government needs to stop allowing states to disarm citizens that they're not a citizen of. Because that's called holding firearm rights hostage. Like I said, Maryland give you everything back but your firearm rights. They hold it through a pardon. So they know what they're doing. 2A rights defender, man, I'm gone. Peace.